Important Bar Rules Series. Will.
Will formation. Validity. Attested will. A will must be signed, in writing, and witnessed by two people. The witnesses must know they are witnessing a will. Together see the testator sign or affirm his signature, and sign during the testator's lifetime. Interested witness. A witness of attested will who is a beneficiary under the will is an interested witness. The validity of the will remains, but a rebuttable presumption is created that the interested witness exerted undue influence over the testator. The presumption can be rebutted by the presence of two other uninterested witnesses, or by clear and convincing evidence that the testator intended the gift. Holographic will, codicil. A holographic will, codicil is 1. That is signed and 2. Contains material provisions. 3. In the testator's handwriting. It need not be dated or witnessed. California recognizes a holographic will as valid. Capacity. The testator must 1. Be at least 18 years old and 2. Have the capacity to understand that he is making a testamentary act, the extent of his property, and relations with family members. Undue influence. Undue influence is excessive persuasion that overcomes the testator's free will, leading to an unnatural disposition. Factors to consider include 1. The testator's susceptibility to influence. 2. The opportunity for influence. 3. A special relationship. And 4. Effort in procuring the will. Either the entire will or a specific gift may be invalidated. Integration. Papers will be integrated into the will. 1. If they were present at the time of the will and 2. There is evidence that the testator intended them to be part of the will, such as attachment, stapling, or numbering. Extrinsic evidence is admissible to show the testator's intent and to establish whether the documents were part of the will. Incorporation by reference. A writing outside the will may be incorporated if 1. It was present at the time of the will. 2. The testator intended it to be part of the will. And 3. The will sufficiently identifies the writing. Changing a will. Codicil. A codicil is a supplement to a will that alters, augments, or modifies the provisions. It is subject to the same formality requirements as a will. When a codicil is validly executed, it republishes the original will as of the date of the codicil, which may cure certain defects. Revocation. A will may be revoked, in part or in whole, by a physical act or through a subsequent will. A physical act involves an act with intent to revoke. A subsequent will may expressly revoke, or impliedly revoke through inconsistencies. Omitted spouse. A spouse is considered pretermitted if the spouse married the testator after the will was signed, and was subsequently never included. There is a presumption that the spouse was erroneously omitted, and they receive their intestate share unless 1. The spouse was intentionally omitted. 2. The spouse was otherwise provided for outside the will. Or 3. The spouse waived their right in a valid agreement. Omitted child. A child is considered pretermitted if they were born or adopted after the will was signed and subsequently never included. There is a presumption that the child was erroneously omitted, and they receive their intestate share unless 1. The child was intentionally omitted. 2. The child was otherwise provided for outside the will. Or 3. The testator had other children and left substantially all of the estate to the omitted child's other parent. Dependent relative revocation. Under the doctrine of dependent relative revocation, DRR, a court may revive a previously revoked will if the revocation was based on a mistaken belief of law or fact, such as the assumption that a new will would be valid. To apply DRR, The proponent must show that 1. The testator would not have revoked the original will but for the mistaken belief, and 2. That the testator would have preferred revival of the revoked will over dying intestate. Revival. The revival of a revoked will must be made by an express declaration to revive in a subsequent instrument. If the revocation occurs through a subsequent will, 1. Revoking the subsequent will does not revive the original will unless there is evidence of 2. Intent to revive. Ademption. When a specific gift is no longer present in the estate, the gift fails, unless there is evidence that the gift was demonstrative, in which case the gift becomes general and does not ademe. Additionally, in California, ademption may be avoided if the gift merely changed form and there is evidence that the testator intended the beneficiary to receive the substitute or equivalent value. Satisfaction of legacy. When a beneficiary receives a gift during the testator's lifetime, the gift is treated as satisfaction of a legacy only if the testator expressed an intent that the gift was in satisfaction of the will. However, if the gift was made from parent to child, it is presumed to be satisfaction of the will. Abatement. When the estate does not have enough assets to satisfy all gifts, the gifts will abate in the following order: residuary, then general, then specific. Relatives may take priority over non-relatives in equitable circumstances. Lapse. If the beneficiary predeceases the testator, the gift fails and falls into the residuary. But under California's anti-lapse rule, if the beneficiary was a blood relative of the testator and left issue, the gift passes to the issue, unless there is contrary intent in the will. If beneficiary is alive, simultaneous death. If the beneficiary and the testator die simultaneously, the beneficiary is deemed to have predeceased the testator, and the gift lapses. Slayer statute. A beneficiary who is convicted of the intentional felonious killing of the testator is deemed to have predeceased the testator, and the gift lapses. The anti-lapse rule does not apply. Intestate succession. When a decedent dies without a valid will, the estate is distributed by the rules of intestate succession. Spouse's share. The surviving spouse takes all of the CP. If the decedent had no issue or primary relatives, the spouse takes all of the SP. If there was one child or parent, the spouse takes half of the SP. If there were 2 or more children, the spouse takes 1/3 of the SP. The remainder is divided by the children or parents. Per capita with representation. Modern per stirpes. California follows this division. The shares are divided equally: 1. At the first generation where at least one member is living. 2. Each living member shares equally. 3. If the taker is deceased, their issue divides the share of the parent. 120-hour rule. An heir must survive the decedent by at least 120 hours or be deemed to have predeceased the decedent. Advancement. Under the doctrine of advancement, property given to an heir during decedent's lifetime is treated as part of heir's share.